May it please the court. There are 2 points of error in this. They are interlocked, so I'm going to briefly discuss the sufficiency issue and then move on to how it affects that second point of error, the Theus issue, which has 2 points within it. First being that the trial court erred in its ruling, and second, that it is preserved for this court to review. So first, it's very important to understand where Mr. Baptiste found himself at the close of the state's evidence. He is looking at testimony that is really insufficient. It's very jumbled. We have testimony that the complainant says she did not take drugs or alcohol that night. We have her sister who says she took methamphetamine, she took alcohol, and we have this insinuation that the complainant's own sister drugged her drink and possibly other people's drinks. So she is sitting next to Mr. Baptiste when she apparently refuses all drugs and alcohol. So that's the testimony in front at the beginning of the night. We move to the end of the evening where there's this giant gap of time. She doesn't remember what happens, gets home, they get woken up by the middle sister who is looking for everybody. She's frustrated, she wants to go to class, she's mad as a hornet, she comes in with her flashlight. Suddenly she's shining flashlights in everyone's face, there's screaming, there's yelling, there's picture frames being thrown, and Mr. Baptiste is woken up by being hit in the head. They're asking him, do you know her? What's going on? He says, she asked me to be with her tonight. They keep hitting him, and like any sane person, he flees. Nobody talks to him after that.
So why does it matter how she ended up in that state, in an incoherent state? All the police officers, the nurses, everybody say she was incoherent and just totally out of it. Why does it matter that it might have been her sister that gave her the drugs, maybe she took the drugs voluntarily? Is any of that relevant to the fact that Mr. Baptiste was apparently having sex with her while she was on the verge of unconscious, if not unconscious?
It does matter because so much of this is about his knowledge. The state has to prove that he knew what state she was in. So if from his perspective, she's refusing drugs and alcohol near him and believes they get into this consensual encounter because he doesn't realize that her drink has been drugged. The state's own expert testifies that you're going to see this arc for the complainant where she's on the methamphetamine, she's up, she's making risky decisions, she is seemingly aware of what's going on around her, and then she hits this crash. All of the state's evidence is in the crash period. Even the testimony, they're talking to her about what's happening.
So then when did the sexual encounter start? During the crash period or in the up period?
We don't know. You can glean it started sometime in the up period because that crash period, when they're found, they seem to be asleep. It's quiet, they've got arms around each other. There's not a lot of activity happening when they're first spotted where they bedded down in that little alcove. So best you figure it was sometime during the up period, but we don't know.
Well, and that's what we do know, though, even if the opponent was unaware that she had taken drugs or had consumed anything that would impair her ability, there was evidence in the record that she was unable to get out of the car, that she had to be assisted, placed into the car, assisted out of the car, that she was stumbling, not coherent when they went into the house. Didn't that give the appellant some knowledge about her ability to consent to sex at that time?
He might have seen some of that, but there's other testimony that she was awake, and we get just a very brief little bit from him through other testimony that he says, she asked me. And that is part of why his testimony was so important in this case, because if you see the proffer from his counsel is very detailed and provides a lot of information that might have been helpful to the jury in making this determination, because instead the jury's having to do pure guesswork to say, well, we know what she was like hours later, And so to say she must have been that way before, or she must, you know.
So on that specific point though, I mean, obviously correct me if I'm wrong, the video, the police officer video, I mean, they didn't have to wait hours for the police to get there. The police showed up pretty quickly. It seemed to me like, it's not like they'd been asleep all night and then she woke up with him on top of her. My recollection of the timeline was, you know, they hadn't been home, I don't think, for a terribly long time when the sister found them in the hallway and then yanked him up and yanked her up, and like you said, the chaos and the fighting, and then they dragged her downstairs and called the police. So why is just the video alone being shown to the jury? I'm assuming they saw it, it's in evidence, not enough for them to determine that she was not in a condition to consent?
Because that all is what happens later. There's not evidence to show that was happening before when they begin this consensual encounter.
But don't you think isn't the jury allowed to make that logical conclusion that if the sisters I mean, there was plenty of testimony that they literally had to, pull him off of her, or, you know, they were actually having sex when the sister found them. And it would have been less than an hour later that the police video was being taken, right? So I just feel like maybe the evidence seems to suggest that not a ton of time had passed. Is there something else you can point me to?
I do not have the exact time in front of me, but they say, I think they got home around 2 or 3 in the morning, if I'm not mistaken, so that's a big gap of time where we just have nothing, and it's too far for the jury to make assumptions for what could have been hours ago.
Well, but Ms. Schwartz, what could have started as allegedly consensual sexual relationship could have turned at some point into unconsensual sex at any time if the complainant had told him to stop, or reached a point in time where she was no longer capable, if she was unconscious or didn't have the ability at that time. It doesn't really matter what happened at the beginning. We have evidence of what happened at the time where they were engaged in intercourse. So does it really matter that we don't have information about how the consensual nature might have started, to your point, that it might have been consensual at some point? The jury had evidence, at least from where they could conclude that at the time the sister found the complainant, the sex was not consensual.
I understand your point, but at the same time, it all just goes back to, there's just not enough there, and there's testimony that they were quiet, they weren't moving, they were still, so it seems like they were possibly.
So she was unconscious, so she was probably not moving very much.
It's not clear if she was unconscious or asleep. There's not testimony really one way or the other. The state assumes.
Is that why you didn't address that part in your brief about the lack of consent?
Yes, there's no testimony that she was unconscious. The state assumes she was unconscious, but it appears more that they were possibly asleep. There's nothing to indicate one way or the other, and it's part of why his testimony in this case was so very vital, and why the trial court's ruling here that kept him from testifying in essence.
Right, so why didn't he testify if his testimony was crucial?
Because of the trial court's ruling, because that prior aggravated robbery and the assault family member are so substantially prejudicial. If he testifies and those priors come in, he's basically throwing his trial, because without his testimony, you do have all this jumble.
Doesn't the case law require him, in order to find error on the denial of the Theus motion, isn't the predicate for that he actually has testified in front of the jury?
It is that he has testified, and when his counsel offers a proffer, that is his testimony presented through counsel. When you look at the rules of evidence, it's 103 about proffers. That can be done as a succinct statement through counsel, or any party can request that it be done as question and answer format, and that is specifically so that topic.
So do you have any case specifically making an exception to the Theus rule, saying that the proffer is sufficient and can be sufficient in lieu of testifying in front of the jury?
There's no case that addresses it directly, but it follows all of the required logic.
So you're asking us to adopt a new rule?
I am asking you to follow the logic behind Theus in all of these cases where there were no proffers. The only two cases where there were a proffer, I think Luce and Matson, both of those were very vague general denials. They were not enough for an appellate review. They were not enough for a sufficient proffer. And in this case, you have his testimony presented via his counsel. So it works for this because you get that testimony that allows you to do the appropriate appellate review.
Does it matter that the proffer was made after the jury returned its verdict?
It does not. It is, at any point when the proffer is given, that is sufficient for this court to conduct review.
But how would we be able to find, how would we evaluate harm if he didn't testify, and so we don't know whether letting in him testifying in addition to his priors coming in, like, wouldn't we need that in order to be able to show that he was harmed?
You wouldn't, because you have all the pieces of the puzzle to do a harm analysis the same way you would with any other proffer that's properly preserved. This is, maybe another way to think of it is it's almost like counsel wanted to submit a redacted piece of information and the court said, no, it has to come in full. And it's a very similar analysis where you can still look at everything that was given because counsel's proffer was very specific. So you could do that harm analysis still to say, here's all of this information he has to provide to the jury. It's so different.
But that testimony is absent the impeachment that would have come in through his conviction. So it is difficult to ascertain the proffer of evidence in a vacuum, because if he would have been impeached with any one of his convictions, we don't know what that testimony would have looked like in order for us to conduct that harm analysis.
Any harm analysis is going to have some amount of conjecture. It's impossible to do a harm analysis without that. And in this case, you've got specific enough information to do that analysis, and the state still would have had some evidence for impeachment because those thefts in that BMV still would have been admissible. But it was the aggravated robbery and the assault family violence in there that caused him to not testify. I see I'm far over my time. I don't know if you want me to keep talking.
Any further questions?
I'm fine.
Thank you.
Mr. Flores may have an additional 2 minutes, should he desire to use it, just to balance things out.
My name is Victor Flores, and I represent the state of Texas in this case, picking up right where the court and counsel left off regarding the proffer. Directly in the state's brief, we cite to Merritt v. State, a 2013 case out of this court, where it addressed this exact issue, whether or not a proffer would be sufficient to preserve error in this exact circumstance. This court held that it would not be sufficient, and it explained why, particularly citing to Luce v. United States, the seminal case on this issue out of the United States Supreme Court. Now, Luce specifically states that a proffer made by counsel would still be insufficient, as Justice Rivas-Malloy points out. This court would still need to, or any reviewing court would still need to speculate on what that testimony would have looked like, because even though that's trial counsel's proffer, there is nothing binding that appellant or that defendant to testify to that exact what counsel proffered before the trial court. Appellant can at any time change his testimony for whatever reason, or even still, the state could choose not to impeach him with it in front of the jury whenever the defendant actually takes the stand. Two major points of speculation: whether the defendant would actually even testify, whether he would testify to the things made in the proffer, and whether or not the state would even actually impeach him with those convictions. As opposing counsel points out, there were multiple convictions at question in this case, 4 in particular, 2 of which opposing counsel concedes were admissible. This court would also have to speculate how the state was going to use those convictions and whether or not the state would have actually impeached with all 4. We don't know what the state would have done. This is hindsight. All to say, those convictions were actually never put before the jury to perform a harm analysis based on evidence never put before the jury would be the kind of speculation that this court warned against in Merritt based on the Supreme Court's case and Luce v. United States. Those 5 factors of speculation, again, the nature of the defendant's testimony are unknown, whether or not the state would have even used them, whether or not there would have been any error based on the admission or not. The key here is this, Your Honor, to the court, is the defendant, let's hypothetically say he would have testified. The trial court rules are admissible, appellant takes the stand and testifies. He can then open the door through his testimony to remove the harm of actually being impeached by some statement during testimony, maybe that he had a character for never being in trouble. He's never been arrested in his life. A defendant can get up and testify, all of a sudden opening the door, and the question of harm goes out the window. Again, we're having to speculate as to what the nature of this defendant's testimony would have been. And just going to the point of sufficiency for a moment, unless the court has any questions regarding theist and preservation.
What is our standard on the harm analysis?
Your Honor, it is a non-constitutional harmless error review, 44-2B, abuse of discretion. And in this instance, the harm analysis, if we were to even presume error was preserved, it would be the state's position that overwhelming evidence established his guilt, number one, but number two, that even still the convictions were admissible. Opposing counsel concedes 2 were, but the other 2 are within the 10-year time window, one of which aggravated robbery, felony offense, the other of which assault family member, a crime of moral turpitude, again, all within the 10-year time window. We believe it would not have been an abuse of discretion or reversible error in any way for the trial court to have allowed the state to impeach with those convictions, Your Honor. With regard to the sufficiency issue, just to point out a few points to respond to counsel. Number one, just with regard to the timeline, it is testified to by the older sister, Kiera, that they arrive home, and after arriving home, within 20 to 30 minutes, that's when everything unfolds. She walks out of her bedroom, she hears the wailing of the victim wailing in pain, crying, screaming, and from there, they confront the appellant, which I would underscore for the court. He did not say, "She asked me to do it." The words, according to Kiera, were the appellant throws up his hands and says, "She made me do it." And so there's an initial allegation of coercion on the victim's part, effectively, is what Kiera testifies to. Not that appellant said that she asked me to do it. There is nothing in the record with regard to a request by the victim to in any way to have participated in the sexual encounter. No, that's number one. The timeline here, as Justice Countess points out, is a tight timeline. Within 20 to 30 minutes of arriving to the house, that's whenever the sexual encounter is discovered. He's confronted, then he flees the scene. Police are then notified, and they arrive at 6:36. The victim would have been discovered at approximately 6 a.m. according to the middle sister, Anaya. She walks in, she sees them together, and there is a discrepancy as to whether or not his arms were around her and her arms were around him. There's testimony that does contradict, that does conflict there. Anaya says they had their arms around each other. However, Andrea testified, this is in the 6th volume of the reporter's record, page 47. Andrea testified that the victim did not have her arms around the appellant, but rather only his arm was around her. Victim testified that his body weight was on her, so she could not move, though she was trying to. Of course, the medical records show that she told the same nurse, "He was forcing himself inside of me." Anaya even went as far to testify that the victim was crying out for help as the appellant was penetrating her. After she had woken the victim up, she then hears the victim crying out for help. This is all while the sexual encounter is happening. The idea that this was consensual, Your Honor, we believe there is overwhelming evidence that it was not consensual.
Mr. Flores, I have a question in that. subject matter area. So how do you respond to the argument that that she, you know, she says she didn't drink, she says she didn't do drugs, you know, she had to breastfeed when she got home. I certainly understand that, makes a lot of sense to me. Is there any wiggle room in there for, you know, crediting him having witnessed that and heard that and thinking that she, you know, she couldn't possibly be intoxicated or inebriated because he did, you know, he was there and he saw that she didn't drink or take drugs? What would that matter? How would that work here?
The state's position would be his knowledge as to her level of intoxication was evident based on the circumstances of the evening, whether he saw the exact moment of the consumption of alcohol or drugs, whether he ever knew that she consumed those at a particular time. Our position is it is not relevant because he sees her condition. In fact, Kiera testifies that when they're driving home, she's of course asleep in the back, but before even that, appellant and another male have to help her get to the car, walk her to the car from the nightclub. Then when they arrive home, as Justice Rivas-Malloy pointed out, she has to be assisted in the house. And all throughout this time, Kiera testifies the victim is intoxicated. And she's then brought upstairs, laid down to go to sleep. Kiera testifies at that point she was, quote, knocked out, drowsed out, and inebriated, intoxicated. And so for the appellant to try to argue that he just didn't know she was intoxicated because he didn't know when she consumed alcohol or drugs, Your Honor, that would be a dangerous precedent. That would a blanket precedent of well, I never saw her consume it, so I didn't know if she was actually intoxicated. Her level of unconsciousness, even if attributed to something other than drugs, was evident on his face to see her in that state, that he would even have to help her because she was so immobile. One portion of the testimony.
Is it possible for a sexual encounter to start off consensual and then change over time, following up on Justice Rivas-Malloy's question, then change to non-consensual?
It is, Your Honor. Our position would be certainly that it would be depending on the circumstances. In this case, based on the evidence, however, we don't see any sign of consent. We do see signs of intoxication, and to assume or to correlate intoxication with consent would be a very dangerous precedent in our position, in our perspective, Your Honor. I'm not assuming or alleging that that's what the court is positing. I just want to be clear that merely her being intoxicated voluntarily or involuntarily does not put her in a position to say that that equated to or even in any way insinuated that she was consenting to any kind of sexual encounter. As this court has noted, particularly in a case very similar to this, Wilson v. State, a near mirror image of this case, Your Honor. Wilson v. State, the citation is 473 Southwest 3rd 889, specifically stating evidence that the complainant was unconscious due to voluntary intoxication is sufficient to prove lack of consent. Those facts in that case were very similar to the ones before this court. Again, even if she had become voluntarily intoxicated, it's our position there was still no signs of consent. Even if she had consented in a hypothetical world, like as Your Honor's pointing out, if a victim does consent, it is possible for that encounter to become non-consensual. In this case, though, however, Your Honor, there's no evidence of consent. There is evidence of intoxication. I think one fact the appellant pointed to in their brief to in any way allege consent was that the victim rested her head against the appellant's shoulder on the way home from the nightclub. Your Honor, we believe this goes directly to the point that he knew the appellant had full knowledge of her condition. She was actually asleep, unconscious on the way home, and she had to be carried to the vehicle, assisted to the vehicle, and then was asleep on the ride home. Now, whether she rested her head against him, Your Honor, we believe that is of no consequence in this case. I would point the court to the body-worn camera where the EMS medical professionals are actually assisting her to the ambulance, placing her on a stretcher. All in that body cam, she is also having to lean her body weight against the EMS. even against another male who's helping her get to the stretcher, placing her on the stretcher. And again, we don't think that in any way insinuated or gave any impression that she was consenting to a sexual encounter with anyone on scene. And so to insinuate that just merely resting her head against the pellet on the way home because she is so unconscious, because she is so inebriated, that equated to consent. Again, we think that's a far stretch that the jury was able to read through and refuse in this case. And the overwhelming evidence goes to whenever she was discovered. 3 eyewitnesses, Anaya, Andrea, and Kiera, all, their testimonies all coalesce here that she was intoxicated, incoherent, had to be awakened while she was being penetrated by the appellant. Your Honor, we believe it's clear that this was not a consensual encounter, and more so, not only because she was unconscious. That is one way the state could have proven it. That is one way the jury could have ruled and could have agreed upon. However, the state also proved it by mere force. Again, the body weight of the appellant was upon her. She could not move. Her own words to the same nurse, he's forcing himself inside of me. In Andrea's testimony, that his arm was around her, but her arm was not around him. Essentially, evidence that she's unable to move because of the appellant. That's clear that his body weight was keeping her from moving. And then her cries for help, her crying in pain subsequent to the encounter, and then his flight from the scene thereafter. Your Honor, we believe it's clear the jury had multiple avenues to find that this was not consensual. We believe all 3 are there, whether it was by force, whether it was because she was unconscious, unable to resist, or simply unaware of what was occurring. We do know that the victim in this case, again, had to be wakened up, and when she was awoken, there was no sign of consent, only signs of her crying out for help.
And remind me again, where did the testimony come from that she was crying out for help?
Your Honor, that's Anaya. Anaya is the sister that testified to that, and I believe that's in volume 4 of the reporter's record, if I remember correctly. Definitely cited in the state's brief, but that is the witness who directly hears her cry out for help, and she responds to that by testifying. She says she believed the victim at that point in time was in danger. She then proceeds to pull the appellant off of the victim, actually, and she testified she had to pull him out of her. Again, in this instance, Kiera even testified, comes out of the bedroom. Her testimony was she believed that he had just raped her. Then she confronts the appellant, and again, he throws up his hands and he says, "She made me do it," and flees the scene after being confronted. And no point in time was the jury given any evidence of consent. I know appellant points to that oral proffer that was made in punishment. Of course, the court, our position is the court should not consider that in its analysis. It was not before the jury. It's not testimony. It wasn't sworn to. In this instance, Your Honor, it would be a prime example of appellant attempting to create a situation where this court functions as a sort of a 13th juror, considering evidence, weighing the credibility of the appellant, but him actually never testifying. Only the jury would have been able to assess the credibility and weight of that testimony. With that, Your Honor, if the court has no more questions. Yes, Your Honor.
Just a hypothetical question. So let's say the pandemic had been worse, and instead of 18 months without jury trials, we'd had 3 years without jury trials, and this case had come to trial outside of the 10-year window would the outcome of the Theus motion have been different?
The burden on the state would have been different. We would have had to establish that the probative value substantially outweighed the prejudicial effect of that particular prior conviction. But with regard to the defendant needing to testify to preserve error, that would not have been different. And in this instance, Your Honor, a reviewing court would still not have been able to assess harm for the same reasons that are before the court here today. The analysis would have changed if error had been preserved, appellant had testified, and had the state actually impeached him with that prior conviction. It would be our position just assessing it because of the nature of the case. If the defendant presents no other witnesses and the defendant is the only sole witness to testify, because of the need to impeach that witness and the probative value on that basis alone, it would be our position that it would still be relevant for impeachment purposes. But if the trial court would have found it admissible, again, that would have been an abuse of discretion standard. We don't believe this lies outside the zone of reasonable disagreement. If the trial court had found it admissible, we believe that would have been well within the bounds of its discretion.
Any further questions?
Thank you, Your Honor.
Thank you for your argument.
This case is unique because it is so distinguishable from all of the other case law that is in front of this court. Merritt was actually about a bill of exception, not a proffer, which are two very separate instruments when it comes to review. And also in Merritt, the bill of exception was a very vague general denial, which is not sufficient for review. We see Luce, which again, very general denial. The logic in all of these cases.
Why is a bill of exception sort of analytically different from a proffer outside the presence of the jury?
Because the bill of exception is really supposed to be something that happens outside of court to memorialize what took place off the record, rather than this offer of proof when the motion gets denied. So they're separate things. And so Merritt doesn't quite apply here. But even if you feel like the logic in Merritt somewhat applies, you still land with being able to do review in this case because of the simple fact that Merritt was a very general denial. There's not the specifics there that are required for appellate review. And in this case, you get those specifics. The entire logic in this whole body of case law is the court can't do review without specifics, which is why you need to hear that information. And so in this case, you get to hear that information. Counsel's proffer is Mr. Baptiste's testimony presented to the court through counsel. And any of the parties could have requested it move into a question and answer format if they wanted to hear more, and they didn't. Everybody was fine with the proffer as presented.
Well, whose burden is it to bring it forward?
Counsel is allowed to pick whether he wants to do it in a succinct statement or as a question and answer format per 103 for the proffer rules. So counsel is acting in accordance with the rules of evidence when it comes to offers of proof. And that should be sufficient for this court to conduct its review.
It seems like we'd have to greatly loosen the standards set forth by the United States Supreme Court in the sort of rather rigorous test for a Diaz motion in order to allow this proffer to preserve the evidence or to preserve the complaint.
Not really, because it follows in line with the entire body of logic set into this. And with Luce, it's about the federal 609, which Texas explicitly did not adopt in whole, nor did they adopt in whole the body of case law around it. They say things like the logic in Luce is persuasive, not that it is exactly what we're doing. And the same thing, it's all about needing specifics to review. And it follows the Diaz logic as well, because it follows the specifics to review. That's why this case is so unique, because most of these cases either have nothing at all for the court to consider, or something so basic and so general there's no way to do a review. And counsel gives a very detailed bit of information about the testimony. And it is at the close of evidence, there's nothing else presented. There's no reason to think this story is going to suddenly fluctuate. And the point about the state could have chosen to not use those convictions. The state fought tooth and nail to have those convictions admissible. So it doesn't track that they would suddenly change their mind and not use those impeachment convictions. It's an odd note there to hang a hat on. I think the more important thing is that aggravated robbery and the assault family member are so substantially prejudicial that if Mr. Baptiste had testified and been impeached with those convictions, he basically would have been throwing his entire chance at a not guilty verdict in order to just avail himself of appellate review, and that's not logical. It makes much more sense to follow the reasoning in all of this case law and say, we have all this detailed information, that's entirely what this is about. The proffer is his testimony, and it can be reviewed.
A lot of the precedent that we're required to follow here does seem unfair. Requires criminal defendants to take very difficult risks in trial, and whether to testify, whether it's, as we have here. So that doesn't surprise me that it would be a difficult choice for Baptiste to make at trial, but we are constrained by precedent, and as I asked earlier, it seems that we'd have to be crafting a new rule in order to afford relief.
I'm out of time. Would you like me to list?
Yes.
So it is not, from Mr. Baptiste's perspective, it is not the new wild rule that's going to result in a ton of cases being overturned, and it's not going to result in the problems anticipated in Luce, where just because the defendant doesn't testify means it's an automatic reversal. You're still in this very narrow exception of needing to give a proffer that is detailed enough for a harm analysis. You still have to get through the harm analysis. You have to say this would have been more prejudicial than probative to get relief. You see all those factors here, but that's, at least with this current body of case law, it's not the norm. So you're not going to see this sudden wild flood when you follow the logic of case law.
Okay. Any further questions? All right. Thank you for your arguments.
Thank you.
Baptiste versus the State of Texas is now submitted, and the First Court of Appeals is adjourned.
Rise.